Algorithms as Intellectual Property by Caitlin Hernandez. An algorithm is a set of instructions or steps taken to solve a problem or accomplish a task. A common example of an algorithm is a recipe, but algorithms are also a fundamental piece in developing technology, where all digital devices and computers are built on to function and perform tasks. Depending on its application and use, algorithms can be seen as simple common knowledge steps, abstract ideas, or valuable pieces of intellectual property. With what constitutes an algorithm being vague and varying, the question of whether algorithms can be protected as intellectual property is common. The treatment of algorithms as intellectual property is not just a question of the law, but of ethics. One such ethical question being raised: under what circumstances should algorithms be protected as intellectual property? To answer this question, two categories of algorithms will be analyzed using the ethical perspectives of utilitarianism and Kantianism. Such categories being analyzed are standard algorithms and proprietary algorithms. A standard algorithm is a specific method of computer computation which is standardly taught in computation to solve specific mathematical problems. Such algorithms include binary search, breadth search, depth search, and more. Assuming that a standard algorithm could be protected as intellectual property, the algorithm would be either treated as a trade secret, copyright, or patent. All three of these means of protection would prohibit the free use of the algorithm to all stakeholders except for the company or individual who protected it. On the other side, if the algorithm was not protected, it would allow the free use to all stakeholders. Standard algorithms are foundational to the education and growth of technological fields. If these algorithms were not available to all who were learning or developing technology, then innovation would stop. Therefore, under utilitarianism, not protecting standard algorithms as intellectual property would benefit the most stakeholders and is the right ethical decision. Using the ethical perspective of Kantianism, would the same ethical decision be reached as with utilitarianism? For Kantianism, the rightness or wrongness of an action does not depend upon the consequences, but on whether they fulfill the duty. Kantianism also embraces categorical imperatives, which are commands in which everyone should follow. The categorical imperative here would be, for others to pursue an education and career in tech, and to continue with tech innovation, then standard algorithms must be available for free use. Standard algorithms are foundational pieces of knowledge needed to continue education and development. Because of this, standard algorithms play a significant role in fulfilling the duty of continuing with education and innovation. Therefore, Kantianism does not support treating and protecting standard algorithms as intellectual property. Proprietary algorithms are algorithms that belong to a commercial company and are already treated and protected as intellectual property. Companies such as Google have developed algorithms which were applied to technology that the public uses. They were able to protect the algorithm as intellectual property, monetize it, and then develop technology based on this algorithm for public use. An example of this is Google's PageRank algorithm that their search engine is built upon. Using utilitarianism, is it ethical for proprietary algorithms to continue to be protected as intellectual property? The stakeholders include the companies or owners of the algorithm, users of the technology where the algorithm is used, and the public. Assuming that such algorithms were no longer considered as intellectual property and could not be protected, all stakeholders would be negatively affected. Intellectual property is what makes the creative process worthwhile to innovators. Without intellectual property, there would be no incentive to invest in or develop innovation. With this in mind, the incentive for companies and individuals to develop unique algorithms would be lost, resulting in a significant decline in technological growth and innovation, which would affect technology users and the public. Whereas, if the protection of proprietary algorithms were to continue, tech would continue to develop and grow, benefiting all stakeholders. Analyzing standard and proprietary algorithms and whether it is ethical for either to be protected as intellectual property. Information and unique characteristics of each were gathered and can serve as criteria for what qualifies an algorithm to be eligible for intellectual property protection. For standard algorithms, it can be determined that they are common knowledge and a foundational piece to the creation and educational process pertaining to tech. With this, standard algorithms are considered as facts and do not qualify for intellectual property protection. For proprietary algorithms, they prove to be different from standard algorithms, as they are unique, complex, and products of creativity and effort. If it can be proven that an algorithm is unique and not simply a set of mathematical functions or steps, then it should be eligible for protection as intellectual property.